All right, now let's get analysis. We're now joined by teams by Dr. Atilla, Kisla, International Justice Cluster Lead at the Southern Africa Litigation Center. Thank you so much for your time this afternoon. I'd like you to weigh in on the ICJ's order, especially, and of course, your understanding on the fact that the court did not explicitly order a ceasefire in Gaza. I mean, it did order, however, that the state of Israel must ensure with immediate effect that its military does not commit the killings of members of the group, causing serious bodily and mental harm to members of the group, and also to prevent and punish direct incitement of genocide. So how does this, how does Israel implement this without the cessation of the fighting necessarily? Just your interpretation of that part of the ruling or the order.
Thanks so much. Thanks so much for having me. I think one will have to see how Israel will implement it once they have to report back within a month to the court, and which kind of measures they have taken in order to comply with the, like you stated, the provisional measures to prevent any acts that constitute acts of genocide. So one will have to see how that turns out. It is true that the provisional measures are not calling for an immediate ceasefire or anything in that regard. But I think these provisional measures themselves have put the international community, and especially the state parties to the Genocide Convention, on notice that there is a plausibility that Israel is potentially violating its obligations under the Genocide Conventions. I think that alone also sends a very important message and contributes, I believe, to negotiations of a ceasefire, or at least builds up more pressure on Israel.
Are there any things, in the order that surprised you necessarily? I mean, was it surprising, for one, that the court did stop short of ordering a ceasefire, and just given that it would arguably, prevent Israel from engaging in defensive military action against Hamas, something that other international communities have even said that Israel has the right to do to protect itself?
I think for many international lawyers, this order didn't come as a surprise, and it also didn't come as a surprise that the court didn't order immediate halt of any military activities. I think what the court tried to do at this stage, will probably do at the merits as well, is to limit itself to a genocide convention. So it didn't actually also speak about the right of self-defense in detail. It tried to limit itself to a genocide convention and the obligations of the states in question here under the genocide convention.
And let's just talk about some of, the way in which they delivered the order. I mean, the court, it spent a considerable amount of time, Dr. Kisla, going into its reasoning for the order. And I think that's important. It did also note that it is plausible that Israel is committing genocide, like you say, against the Palestinians, and recognize, that the Palestinians are a protected group under the Genocide Convention. What does this then mean, just given, the fact that the court is yet to deliberate on the merit or intent stage of the case, that genocidal acts have been committed by Israel?
So at this stage, what the court did is that it did not decide whether Israel is guilty of committing acts of genocide or failed to prevent any acts of genocide. What the court decided at this stage are preliminary measures. So its standard at this stage was the plausibility of potential violations of the Genocide Convention. And in that regard, it of course looked at the plausibility of such violations, but also at the risk of an irreparable harm, and in order not to prejudice the case on the merits, which will come maybe only in a few years' time, it issued these provisional measures, measures like, for instance, reporting back to the court, or another provisional measure that the court ordered was to that Israel must prevent any destruction of evidence and must preserve the existing evidence.
And I want to talk about that, reporting back to the court. The South African government saying that it hoped that Israel would not act to frustrate the application of the court's orders. I mean, one of the orders, like you're saying, is that Israel submit this report to the court in 1 month in terms of, progress. But just unpack a little bit about your understanding here in terms of what the court's expectations are and what Israel might then do in terms of, or the implications if it doesn't.
I think my understanding of the report mechanism is Israel must disclose what kind of measures it has taken after the provisional measures has been ordered by the ICJ, and in that regard it must show that it's complying with the provisional measures. We will see, it remains to be seen whether Israel will indeed report back or will indeed take measures in accordance with these provisional measures. We have seen some of the reactions from Israeli authorities yesterday, and in the case of Russia, for instance, there was no reporting or no reaction to any of the provisional measures. So it remains to be seen if and to what extent Israel will implement those kind of provisional measures.
I want us to turn a little bit our focus on, the judges themselves. I mean, some issues of legitimacy and the reputation of the court may have come to light, before this particular judgment, given the fact that some of the member judges are elected by their various countries. How important is it then that the court remains impartial? I mean, we saw in terms of how the judges voted, on the various preliminary orders, and there were some questions in terms of, how much of this, of course, was a sense of, the judges have some level of independence away from the political matters.
I think the independence of the judges is crucial and the foundation of any court. So that applies to any local court or the ICJ. What we have seen, I think, quite remarkable is also that the Judge Barak, the ad hoc Judge Barak, who was nominated by Israel, is actually saying in a statement that he's not an agent of Israel, he was nominated by Israel. And that was also illustrated in 2 provisional measures that he actually voted in favor. I think it was the provisional measure on taking all measures to prevent any incitement of genocide and delivering or enabling basic services as humanitarian aid. I think it shows that these judges are not just agents of the states that they where they are from, but that they are independent, and independence of the judges and impartiality, of course, is crucial for any court.
And just on some of the judges' findings just before. Of course, we saw that the judge president, Joan Donoghue, spent a considerable amount of time, just citing statements from reports, particularly hinging on the UN statements. I mean, how significant was this, considering that, of course, it had to base some of its decisions on some of those statements that were made?
I think it was crucial. It was also crucial to provide the context in this matter. And I'm not sure to which exact statements you're referring, but in the statements that were referred to, also not only from the UN side, but the court used public statements by South Africa and Israel to actually argue or conclude that there was a legal dispute between South Africa and Israel, because that was one of the arguments that Israel made in the hearings 2 weeks ago, where they said that actually there is no legal dispute, and where they were arguing in terms of the note verbal they sent to South Africa, where they stated that they would be still open for consultations and communication on the issue. So I think in that regard, it was very wise from the court to point all these opposite views out and also provide the important context in terms of the statements made by the UN Secretary General or any relevant UN authorities.
And finally, I suppose the question is, what next? You know, we know, of course, this was but one part of this case, this particular case, and that, of course, the court will then deliberate on the merit of the genocidal acts and, of course, the intent thereof. So what is the next steps for the court, and how long will this process take?
It's difficult to say how long the process until the court is getting to the merits of the case will take. It could take a few years. We'll see how long it takes. But for now, from the court's end, it will wait to see the reports from Israel and if it reports and to what extent it reports. And on that basis, I'm sure, go into the merit stage of this matter. We'll have to see what kind of effect the provisional measures will have. And what they definitely did is, while the court is not saying that Israel is guilty of any violations of the Genocide Convention, it clearly shapes the public opinion and builds up pressure on not only Israel, but also its allies who are supporting Israel with, for instance, aid or in terms of arms, to maybe think twice that they are delivering arms to a state where the International Court of Justice has actually held that it's plausible that potential violations of the Genocide Convention have been committed.
And I mean, to those last points, it does compel somewhat, and it does give Israel a legal obligation, you know, to prevent genocidal acts if indeed, you know, they are found to have been there. That certainly has come across very strongly from this process, whether one believes that South Africa was victorious or not in as far as this case is concerned. But thank you so much for your time on the program. Really do appreciate it.